Thank you, Farhan, and thank you for I thought it was ECUSA, like COSA as well, for having me. I really enjoyed talking about U.S. immigration, people that could really use it, and thankfully the country is open, and a lot of people here, as this group attests to, are in need of this information. So I'm happy to be of service. So with that, I thought I'd do a little introduction of myself. My name is John Khosravi. I was born and raised in the United States, in Los Angeles, and I'm headquartered here as well. I kind of fell into U.S. immigration unexpectedly about 10 or 12 years ago, and I fell in love with it. My parents are immigrants, but I wasn't aware of any part of it until I got involved as a lawyer in it, and I found it to be an excellent area of law, primarily because at the end of the day, you're always helping an individual person. And I always like the characters that come, the personalities and the adventurousness, the fearlessness of immigrants, because as everyone in this group has gone through, and I've seen it so consistently that it's not an easy thing to just pick up and leave your home country, go to somewhere you don't know, in a language that you maybe don't speak, or as your second language, and to just start a life for yourself. So being around these kind of people has always been, a blessing for me. Now, I've taught immigration law at Loyola Law School, at Pepperdine Law School. I have courses for immigration attorneys called the Immigration Lawyers Toolbox. And I'm also the editor and president of the Immigration Lawyers Toolbox magazine. It's a trade journal, trade magazine for immigration lawyers to get information, what's going on in the field and training and all that kind of stuff. I have a podcast. I have two podcasts. Well, one of them, again, it's for other lawyers, primarily for training, called the Immigration Lawyers Podcast. But I also have several different podcasts for regular people who are interested in the immigration process. Just put my name or John Khosravi or JQK Law, and it'll pop up. Also on Wednesdays at 6 p.m. Pacific time, I have a live question and answer session, a Q&A, where I go into U.S. immigration and take questions live on YouTube, Facebook, LinkedIn, and TikTok as well. So you can always just put my name in and you'll find that information. Now, I'm getting a little bit better from the cold. I have two kids who get sick every week now that school started, and it always hits me a little bit. But I'm just going to jump into it and go talk about different aspects that I primarily want you to be aware of as a safety thing. That's where we're going to start off first, and then go into other benefits in the future of what you can do. If you have questions, put it in the Q&A or the chat. I'll try to fit them in while we're talking. If they don't fit there, we're going to put them at the end of the show. So with that, let's get it started. All right, so what I always like to do and what immigration lawyers are supposed to do when we have our initial consultation is to just make sure you're okay. That's, when you go to the doctor, they check your heart rate, your weight, how tall you are, all these basic stuff just to create a baseline. And that's what we always have to do when we start the case. And this is where potentially scary stuff could pop up, because the way the immigration laws are set don't make much sense a lot of time. And things that seem innocent mistakes, or things you're not aware of, could really come back to hurt you. So I really want to always go back and learn about the applicant, the person who's applying for an immigration benefit, and see what's going on in their lives. Where were they born? So it literally goes back to where they're born, because later on, for example, if you want to apply for a green card, we're going to need to see your birth certificate, marriage and divorce certificates, and things like that. Adoption records, sometimes if you're adopted, and many times people don't go through the formal adoption process, don't have that. Many times they get married, divorced, don't keep proper records. But a problem I'm seeing consistently every week recently is people's birth certificates not being properly written. Either they're created too late, they're born, and then 10 years later the birth certificate is issued, which is very problematic. USCIS, the U.S. Immigration and U.S. USCIS, U.S. Citizenship and Immigration Service, the Immigration Department in the United States, it's gotten very strict on this aspect. So we always want to see, is the name correct? Is the date of birth correct? I've seen many times where people's names are misspelled on their own birth certificate, and they don't see this until they're 30 or 40 years old. And most importantly is it properly issued? Does it have the stamps? And how soon was it registered after birth? Ideally, the birth certificate is registered within 30 days, but sometimes it isn't. So I always tell clients, the first thing I want to see is that to make sure that's not a problem. Some countries don't have birth certificate. If you're older, from India, and you're 50 or 60, you may not even have a birth certificate. So you have to think about alternatives to that. Now, if a lot of you are here, and actually I would appreciate it if those are attendees if you can, list what country you're from and what status you have in the United States. It'll help me fine tune my message to those countries, so you'll get more specific information, as well as the visa categories that you're under. So if you had time, just please post that there. But various countries have different requirements, like military conscription. You're required to do 2 years from Greece, Iran, and various countries in the world. And what's really important is you have to list these in the DS-160 form that you use when you get your initial visa. Everyone does the DS-160; it's a requirement. But a lot of times, after the fact, we see that they didn't put the proper work history in there, education history. If it's asked, they don't really go too much into education history. That's more the green card. But they do ask about military service, weapons training, and the like. And if you don't tell them there, potentially later on when you ask for a benefit, they'll say, well, you lied in your initial application, and it's a downhill situation from there. So you really want to see, did you get your visa properly? Did you fill out the proper paperwork? Many people from Europe use the ESTA program, which is a visa waiver. They made it easy so that you don't have to get a tourist visa. You go online, you fill out a short form, and they give you a 90-day permission to visit the United States. But even today, I had a gentleman from the Netherlands who didn't list prior overstay on that and forgot about it and submitted it and got the visa waiver. But when we were talking, I said, listen, you committed potentially fraud or misrepresentation. We got to fix that. And it's very difficult to fix because you didn't fill out the form properly. So these things seem innocent. Many countries in the world are not that strict with paperwork. They'll accept your answer and say, oh, I wasn't paying attention. Not the United States. They're looking to see problems, looking for problems to hurt you. It's really that bad. Now, we have a justice system in the United States that says you're innocent until proven guilty. Now, that's a criminal system inside the United States. Immigration is the opposite. You're guilty until proven innocent. Even if you're applying for a non-immigrant visa, like a tourist visa or something, the rules say we assume that you're going to violate your status and on whatever kind of temporary visa you have. You're just using that as an excuse to come into the United States to be able to work and live here and not go back. And they start with that presumption, and it's up to you to make them feel differently about it. And they only give you 30 seconds, as many of you who've gotten an interview have seen. They only give you 30 seconds to talk, and they're probably not even listening to you. They probably made their decision already before you walk in based on the forms and the paperwork. And that's why it becomes so important to have this paperwork properly submitted, because even if you go with tons stacks of papers to explain your situation later, they don't want to look at it. They don't have time. Some of these consular officers are reviewing 100 to 300 cases in a day, so they don't have the time to pay attention to you. So that's why we always go back and see, hey, did you list your information properly? Did you list your marriages, military history, work history, all this kind of stuff to avoid these kind of problems. Now I see we have a lot of people with J visas, H visas, a lot of people from Spain. And so, being from Spain, there's document issues there. The birth certificates expire and the like. So there's a lot of documentation I could get into. I'm not sure how much I'm going to get into that, but a lot of J's. Okay. So good to know. Thank you so much. Now, the next thing we worry about is when someone comes to my office, if they're not overseas, they're already in here, did you maintain your status properly? And this then goes to, what is maintaining proper status? Now, we have a couple of people on F-1 student visas, also J's, but the J-1 culture exchange visa many times has a component. It's really based on you coming here to do research that you get paid for, and they know beforehand. But when you're coming here on something like on an F-1, a student visa, that becomes problematic because you're not allowed to work on an F-1 unless you have specific permission, either curricular practical training, CPT, or later after you graduate, OPT. And so a lot of people may do some odd job here or there, or have a summer where they go and do an internship they're getting paid for. These are potentially violations because you have to tell your school, your international office, that you got this. Many international offices don't know what to do. They don't listen. They say it's okay, and then they cause you to, they let you violate your status. So you got to be very cautious. And although it's expensive, it's always good to have your own immigration attorney to talk with, because the international offices have a high rotation. A lot of people come and go from there. And this stuff is so complicated, it takes so much time to learn that they don't necessarily put that time in. Or the school is so small that the person in the international department also have 10 other duties that they can't fully focus on this. So frequently I see international offices of some schools mess up big time. So you want to maintain status properly, not violate it by working. One issue that pops up are the marijuana laws in the United States. Now, US has 50 different states. Imagine 50 different countries in one country. Some of these states or sub-countries have made it legal to use marijuana, but the federal government, and immigration is a federal law, it's still a complete crime to use marijuana and be associated with it in essence. So that just because maybe in California and various other states it's legal, it's not for you if you're an immigrant. Wait till you're a citizen, then give it a shot. But using marijuana or being around it is going to be a problem. Another thing, when you are on these statuses, eventually there's a grace period, a time where your status ends, and you have a window of opportunity, 30, 60 days, depending on whether you're on like a J or an F or something like that, to stay in the United States before you have to leave, to kind of, do your last visits and clean up the things you need to and leave. Now, during that time, the regulations are not well written, but you could extend status or change status to do that kind of thing in that period of time. But it's just something to be mindful for. That extra time exists, and to use it wisely and if you need to. But it's always good to plan way ahead of time before your status ends to have that. One note I want to make for those on OPT, we have a lot of people here studying sciences. OPT is for 1 year. You get 1 year of working after you graduate. Make sure you do the OPT paperwork right. I frequently get people who submit it late. Their I-20 has the wrong date on this and that. And if the OPT work permit is denied, you're out of status, you're out of luck. There's no real way to fix it up, and schools usually don't help you do that. So that's 1 year. And then if you're in a STEM major, science, technology, engineering, and math, you potentially get more time. But when you're going to be a STEM OPT, that extended period of time, the employer who is going to employ you has to be part of a thing called E-Verify. It's a system where their computers, where they look up their employees' backgrounds for immigration, is connected with the government to verify the information is correct. Not every company, most companies are not like this. So you may be on OPT, you want to get STEM OPT, and you're happy you got a job, but they don't do E-Verify. You cannot use STEM OPT with that job. It's going to be a big problem. So that's something to be very mindful of. And with regards to the J's, which have a lot of here, you got the big problem potentially of the 2-year home residency requirement. And this is something that started in the initial parts of the J visa, where they said, if a person is coming here as a cultural exchange student, and we want them to come learn this knowledge in the United States and then go back to their home country and over there share that information. And so not every country is going to be subject to this. Not every field of study is. There's a list of countries that could be subject to it, and then what areas of study that could be problematic, that could cause someone to be subject to the J-1 home residency requirement. So it's very important to be mindful of that. If you're coming in on something called the Fulbright Scholarship, you're automatically subject to the 2-year home residency requirement. And it's much harder to get that waived. So even if you are subject to the J-1 2-year home residency requirement, it's potential that you could get a waive. Fulbright is harder. It's not impossible. I've seen it happen, but it's much more difficult. The waivers are based on hardship. It's based on the fact that you may have, your home country may say it's okay, but there's much more nuance to it. For example, if you're a medical student, even if your home embassy okays it, they still want to prove it. You have to get the waiver based on some sort of hardship or that kind of thing. So be mindful of that, especially the medical students. Now, if you're worried of whether you are subject to the 2-year residency requirement, usually they will put it in your J-1 visa. Also, your DS 2019 will list it, but you got to be careful. They don't always fill out the paperwork correctly. So even you may be subject to the J-1 2-year residency requirement, but it's not listed on your paperwork. And later on, you try to do something and it becomes problematic. So you really want to check to see if your country's on the list, what your study's on the list. Are you a Fulbright, this and that? Are you a medical student coming here for graduate work? And then take it from there just to double check, because they make mistakes on this stuff all the time. If you are subject to the J-1 2-year home residence requirement, it means that you're not allowed to change status in the United States. So if you're on the J, or you come on a tourist visa B2, for example, you can't change status in the United States. You have to leave and get a visa, but you're not allowed to get certain visas. The H-1B is not permitted and the L-1 is not permitted unless you wait out the 2 years or you get a waiver of the 2-year home residency requirement. So you got to be very mindful of how this could affect people. I have a case right now, someone from Mongolia subject to the J-1 home residency requirement, and she found a husband, a person she fell in love with, getting married, and it's going to be really hard to waive it. We're going to try, but she's going to go back and try to wait it out. Maybe the waiver is going to happen, maybe it's not, but she's going to wait out the 2 years and then get the green card through her U.S. citizen spouse. He's going to go visit her in the meantime, just so he could get the 2 years done. And they literally count it sometimes. Some officers are really strict. They want to see the airplane ticket that showed you went back home, and you're supposed to be residing in the home country as is written in the rules that you were before you got the country you're resident of. Just continue it there. Now, some officers will count the days. Some will be more lenient. But on your own, you want to be most conservative of just counting the days if you're subject to this requirement of going back home. So those are just some the things I try to look at first. Check it's like doing X-rays or something like that to make sure people don't have these issues, because there'll be a problem with the J1 2-year home residency requirement. You can't get a green card until the 2 years are done or it's waived. So that becomes a big problem. I've had couples constantly. I do a lot of marriage cases where they just find out on my consultation they're subject to it, and then we got to figure out how to deal with that. So the sooner that issue exists, the better it is. All right, so let's talk about what options you have after graduating. Let's say your J1's done, your F1's done, you want to know what to do. There's always the option potentially continuing education, continuing the J1 work in some way or another, just staying in the same position. Be mindful if you get a waiver, for example, the J1, then you do some more J1 work, you may be subject to the 2-year home residency requirement again. So it's a very tricky kind of situation. But other than that, let's say there's no issues and you're finishing up your OPT on F1, no J1 issues. What are you going to do afterwards? You're done in the United States. So you could always change status to a B visa. B visa is a temporary thing of just being here for like 6 months to do some negotiations or tourist kind of stuff. That might buy you some time. So you're nearing the end of the J1, you do change the status to B, to say I want some time to spend in the United States, have fun, go to Disneyland, drive around the United States, check it out. Now the problem with this and all these categories are that things are hugely backed up. So you could do a B, change of status, or change status to an F, for example, your J, you want to change status to a student visa. It might take a year for them to even get around to looking at your application. Now the tourist visa, the B, is only for 6 months once it's approved, but it might take them a year to read it and approve it. So it's really messy. A lot of these times, normally we'd say just go back to your home country, do a visa interview and come back, because it's much faster to get a visa interview, but that was pre-COVID. And right now the big problem is if you leave, on November 8th, they loosened it up where if you're vaccinated, you could come in. But a lot of the embassies are not in full order. So it's really hard getting a visa appointment for many of these categories. If you're from India, essentially they're shutting things down. A lot of countries don't do tourist visas right now. So it's a lot of problems this and there. That's why planning comes into place to see what the best option is. But the tourist visa just buys you some time to be here, maybe do some negotiations, maybe you'll talk to some people and you find a job that they want to hire you. I have a quick question. If you're doing the waiver of the J1 under H-1B visa, can you get married and file for green card, or do you need to finish your waiver? So I'm not sure what you mean waiver the J1 under H-1B visa, because if you're subject to the J1 2-year home residence requirement, then you can't get an H-1B visa. And so that's that. But let's say you're subject to the J1, you want to get married, you have to get approval by the Department of State of the waiver first before filing for the green card. So there's a lot going on there. It may be possible. There's a lot of times the basic waiver has 3 parts to it when you're dealing with your home embassy. Home embassy approves the fact that they're waiving the requirement. The Department of State then approves that, then USCIS has to approve it. So there's 3 approvals you have to get. But if you're going to file for a green card in the United States, a process called adjustment of status, we're going to talk in a bit, you need to have at least a second approval from the Department of State in most cases, but it goes into a lot more detail from there. So it is possible to be a J and then go to other categories, H-1B, green card, if you're not subject to your home residency requirement. So that's another question that was asked. That is possible. All right, so we talked about the B. Another one I want to talk about is the E visa. Now we have a lot of people from Spain here. We have from Israel. We have, where else do we have? Spain, Peru. Peru doesn't have it. I think Peru closed up their E2 investor visa option a couple years ago. I'm not sure. Ukraine has it. A little bit hard, but it's there. I see we have an internal medicine resident right here. They probably are subject to a 2-year home residency Blanca. So that be mindful of that. You may be subject to it. But we have a lot of people from Spain. So Spain is really good. They have this thing, a treaty with the United States from many years ago, where they said, if you have a Spanish passport and you enter with that passport, or just have one in general, I'm getting too complicated. I don't want to get too complicated. I'll keep it overview. But if you have a Spanish passport, you can potentially, if you have a business in Spain that does most of its trade with the United States, or most likely you want to start a business here, you could just come and start a business here. So as a lawyer, let's say I'm a Spanish lawyer and I want to open up a shop in the United States and start a law firm. I could come here, lease a place, get some desks and that, and ask for an E2 investor visa. Say I'm vested in this company and I want to live here and operate. Now it doesn't lead to a green card. So that doesn't happen. There's another program that leads to green card. We'll talk about that later. It's not a good program. It's a waste of money for most cases, but we'll talk about it. It's called the EB-5 program. But the E2 allows you to stay here and operate your business. And the first question gets asked after that is, well, how much do I need to invest? And there's no minimum. All they ask is it has to make sense. So if you've seen the show Shark Tank or Lion's Den in Canada or UK, you go talk to an officer at the embassy, or you submit the paperwork in the United States USCIS, and you have to sell them and say, listen, I invested this amount of money. It's all I need to be a success here. This is my background. And let me do it. And this is really good for investors in tech companies as well. If you're starting your own tech company, if you could sell them, if they believe the fact that the amount of money you're doing with your background is enough to make some money and get the business going, potentially hire an American or Americans in the coming future, and you have a business plan for that, kind of setting it out, and they believe you, and you could get it. So it's a really good option. Doesn't lead to a green card. Will have to be renewed consistently. But I've seen people be on this E, and come with their spouse. They have a kid that's a U.S. citizen. This is rare, but they have the E for 21 years, and eventually the child becomes a 21-year-old citizen, and they file for their parents' green cards. This kind of stuff does happen. Or you're on the E, eventually after a couple of years, 5-6 years, you fall in love with a U.S. citizen, and you get married and adjust status. So that's something that's possible with the E visa. And so that's I'm looking at the chats right now to make sure I kind of cover this stuff as we're going. We got a bunch of questions. I'll go back to in a second. Now, the next thing I was F, which is, I'm just going in order of letters. We kind of talk about the F. F is a student visa. You could always change status to that and start studying. Student visas do get, a year of training after they graduate, or even during school. They could do curricular practical training. Sometimes your courses require you to study do active work as well. Just be mindful, if you're actively working full-time for a full year, that will take away the OPT option. So it's something to be careful of. And when it comes to OPT work on the student visa, let's say you have a bachelor's degree, you get that 1 year. And then if you decide to do another major and get another bachelor's degree, you can't get that extra year. You have to keep moving up the level. So you go to master's or PhD, and to get that extra year, you always have to be moving up on the hierarchy. Now, the H visa is a big one that people are part of. It's problematic visa because of the fact that there's a limited number of these. So many more people than the number of visas that exist apply every year, so fewer get it. During Trump's administration, President Trump, they were really strict. They were denying cases. They were taking forever, where we had cases submitted that were good to go, would take a year to get approved. And so it's really disruptive in your planning. The employer doesn't know what to do. The basics are this: every year there's a lottery. You have to, put your name in the hat, and then they'll pick it out and they'll name some people. And you or your lawyer, really the employer, will get notification that they're chosen. Most won't get chosen, majority. And then they submit the H-1B application, and then they wait to get an approval on that, and hopefully happens sooner rather than later. There's a lot of problems that exist under Trump that are making this super difficult, but it's gotten a little better. But it's just something to do. And if you're in these, if you have a degree, this is what people typically do historically, the H-1B visa. Now, the L visa may be an option as well if you worked overseas for a company for 1 year out of the last 3 years, and you're in an executive or management or specialized knowledge section. These terminologies aren't what we talk about normally if we're talking with somebody. They have definitions that are very strict, but at the same time, they're unknown. So it gives the regulation just says if you're an executive and has this definition that's very vague. But in practice, you see that they read it in a certain way, and you have to really match that. It's really complex, but it's possible. And what it says is if you work for that company overseas and you're going to be transferred to an associated company that, a subsidiary of that company, majority owned by the foreign company, or there's different formulas of how the corporate relationships of the U.S. company and the foreign company work. So it's too complex to talk about here. But you could transfer over, and eventually the L1 can be a green card called the EB1 C visa, multinational manager, or you could just bypass the L1 if you worked abroad for 1 year for a company and moving here, and just go directly to the green card option as well. The big one I want to talk about right now is the O1 visa. Now, I'm the publisher of the Immigration Lawyers Toolbox magazine. If you just go to immigrationlawyerstoolbox.com/magazine, you'll see previous issues. The most recent one I published was a special edition just on O1 visas, and I had around, I think, 20 immigration lawyers write articles on different aspects of the immigration of the O1 category, what you could do with it. So I think it's going to be really interesting for all of you to check that out, because you'll learn lawyers that are doing different aspects of this and see if it matches what you're looking for, or gives you just education on it. It's written for the immigration attorneys, but it's something that's going to be really helpful. Just go to immigrationlawyerstoolbox.com/magazine and check that out. But the O and the P is, a lot of these are sports will do this. The P is for groups coming in, but you're probably looking for an O And if you could show that you're one of the top people in your field, you may have gotten a lot of funding, you might have won awards, you graduated from top schools, you've done some research that's game changer, all this kind of stuff. And you can argue that and if you have some work lined up in the United States, you say, hey, I need to work and I need to be here. Please hook it up and let me get this approved so I can continue my work here. Because the H-1B is limited, the numbers it gets, what we've seen in the last few years is a rush towards O-1 visas, and it's been a lot of success there, something that could be renewed frequently. They sometimes are strict on it, sometimes they're not when they're adjudicating these, but that's an option for a lot of people in your field to do, and it's very interesting. And then finally, I want to reference the TN, these trade visas, which permit certain countries. The TN itself, now it's called, they changed the name, Trump redid their agreements, I can't remember what it's called, but they essentially people with Canadian citizenship, if they find certain types of jobs, they can come easily to the United States to get the visa. This also applies for Australians. There's the E3 visa. There's the H1B1, I think, for Singapore, people from Singapore, people from Chile that could come and do that. But these options do exist. And kind of going back on the E-visa, the investor visa, let's say you're from Israel and this company has an E-visa, the owner has it. You as a fellow Israeli could come and say, I need to work for this person, I'm skilled and I know their stuff. You could also transfer over. There's restaurants here owned by Italians, for example, major chains and stuff like that, and they send over their employees, similar to the L actually, but they could send top employees into the United States to run operations there. So that was the really fast overview of non-immigrant visas. Visas where you're coming temporarily to work and live here, but you have to go back, as opposed to an immigrant visa, a permanent visa, where you either file for adjustment of status, which says, I want to change what I have to adjust it to a green card, or you go through consular processing through the embassy abroad. I'm going to take a second to look over the chat really quick. I'm Italian, J2, currently work in the USA. My company's available to sponsor me. That's good. I'd like to more community ask, is it possible to go from J2 to a green card? Yeah, it's possible. When it comes to questions about how long these things take, it's really difficult to answer because I know exactly what's going on and specific program we're using and your background. Even knowing all of that, the government's inconsistent. Some cases will take 3 months, some take 3 years. So timelines, I'm not gonna be able to answer realistically. So I'm gonna put that away. But if you are on a J or J1, I mean, is it easier to ask for H-1B? It really is up to the employer, because the employer is the one who files for H-1B. And for employee-based cases, other than 2 exceptions, it's the employer who's gonna pay for it and do the case. So, it's whether it's easier to ask or this, it depends on what the employer wants to do and what your relationship is. If you're worried about, will the employer do this or that, it's up to how much they want you, So that's why it's really important to be really wanted. The question, does this mean we can start a company while on H-1B, J-1, or F-1 visa? This is a little tricky. Everyone's allowed to own property in the United States. So everyone could come and just open up a corporation or something. Now, sometimes USCIS I have seen come back and say, oh, when you started your corporation, there's certain paperwork you have to file with the state that you're living in. And to make it easy, you just list yourself as the president of the company or something like that, just so be able to submit the paperwork online, but you're not actually working in the company. Sometimes they'll come back and they base it on this one case where this guy was on a student visa. He launched he had extra money. He purchased a car dealership or started one up, and he had employees selling cars there, but they said you were doing unauthorized employment because we assume you're going to sell cars over there. Even though the guy argued, yeah, I just registered it in my name just because I had to register it and I didn't have anyone I know to do it, but I wasn't working there. They didn't believe it. So this is rare that they'll hit you with this, but it's possible. So you can open a company, but you got to be very careful. Hopefully you have partners or something who could have their name out front to show you're not working in the company. So let's say you're on an H-1B visa, you're only allowed to work at the company that gave you the H-1B or the J-1 or something like that. But if if they think that you're working at that company you started, it's going to be problematic. Unauthorized employment could be a big issue. So you want to have partners to show other people are doing it all. On the F-1, on OPT for F-1, you can start a business and you could be self-employed on an F-1 OPT. So we have cases where someone's on a student visa, they have their 1 year of OPT. We say, hey, listen, start your own business, do the proper registration for it. And then if the business is successful, we'll change that F-1 OPT to an E2 investor visa. And that'll give you some runway, some time to see if this concept for a business that you have is actually going to happen or not without going through all the headache and costs of actually applying for the visa. And so we have another question about options for entrepreneurs. So that's it. It's the E2. The O1 is sometimes the option and stuff like that. That's that. I would really appreciate if you could talk specifically about most typical cases of scientists in the United States, F-1, J-1, H-1 cases looking for a green card, which we're going to get to right now. And could somebody share the link about the immigration magazine? I'm going to type it up here in the chat. It's if you just go to Immigration Lawyers Toolbox.com/magazine, or just type in Immigration Lawyers Toolbox.com and then magazines want a tip. Scroll down, you'll see an issue that has like 20 different lawyers' faces on there. The articles there, check it out. Now, we have also a Q&A. I'd like my husband to join me soon. He's self-employed in Spain. I'm not sure if he can continue working for Spain while he comes with J2. I'm afraid it's not possible. Could he come with J2 only for a week, request EAD, and continue working in Spain until he gets EAD? So this is a big issue, and I'll talk about it because historically, you're not allowed to work in the United States without work permission unless you have a certain category that allows it. But nowadays, we have this technology where you have a job back home and you can work here on your computer. Is that unauthorized employment or not? The statute, the regulations are too simple. They're from 50, 60 years ago. They don't foresee this kind of thing from happening. So we don't know exactly. Different officers will deal with it differently, and that's a problem. So it's inconsistent. I would not recommend someone come and do that. But what I've seen, for example, with Customs and Border Protection, CBP, the officers with the guns you'll see when you enter the airport that look at your passport, generally their policy is if the employer is the person paying you for the work is not located in the United States, it's a foreign entity, they're paying you, for example, on a foreign account, then yeah, it's okay to work. Having said that, I wouldn't recommend that because that's Customs and Border. They may let you in the country with that knowledge, but later on, USCIS, some officer for a green card will say, no, you did unauthorized work. We're gonna deny your case. So it's really troublesome. And if you come in and apply for an EAD once he's in the U.S., he's gonna have to maybe he could fly out and wait it out, but he's got to do some fingerprints too for that. So you have to wait for that to happen. Let me see. All right, so one question, F-400 for citizenship. We're not gonna get too much into citizenship. That's how to get your green card. Our folks will be on getting the green card at this point in our discussion. So yeah, we have a lot of scientists here, a lot of tech people. What options do you have? We have this program for green cards. I mean, there's marriage. You get married to a U.S. citizen, a green card holder. You may have a relative. I mean, there's more nuance to that, but this is it. A lot of my clients, actually, I'm in Los Angeles. We have a lot of UCLA people among my students and Stanford people. I got a client for Stanford once, and then they're telling with friends. So we have a lot of clients for Stanford randomly, but UCLA, USC, I have a lot of people, grad students, fall in love with a classmate. They come to me, and we get the green card. So that's possible, but that's family-based essentially. A lot of you, if you're not going the family-based route, have to work with another thing. Employment-based is the main thing, but I want to mention the green card lottery, the diversity visa program. This is an interesting one. I recommend everyone filing if you could. For countries that don't have a lot of visas requested from the green cards, they say, hey, every year, they just close the window for it. So you have to go for next year if you want to apply for it next end of September. But yeah, you file for the diversity visa green card lottery, put your name in there, and then up to 50,000 people are chosen, usually like less than half that actually get the green card. But they're chosen to apply for a green card. And so it's something to do. Why not? Give it a shot. You might just get your green card that way. Many people do. But the big chunky ones are the employment-based categories. They're generally put into 5 different categories: EB1, employment-based 1 through 5. Employment-based 4, EB4, I'm going to push out of the way. It's this nuanced kind of thing. If you're an Iraqi interpreter, or if you're, you had a marriage case pending, your spouse dies, so it's like this weird catch-all category. We're not going to get into that. If you're, a person who's coming to work in a church or a priest or something like that, they have special green cards. So we're not going to talk about that one. EB5, we're going to get rid of the ones at the end, is the investor program. This program is fraught with problems. The government didn't renew parts of the program. The price went up and it went down. But essentially, you put a lot of money and hope that the investment creates 10 full-time jobs in the United States. And after, a couple of years, you might get a green card, may not. And you have to maintain those jobs. You may keep the green card, may not. Really badly designed. I only tell people to do this to say, listen, if losing $500,000 to $1 million for you is not a big deal, you're not going to, you still live, then do it. So ideally, you'd have millions of dollars, so this one aspect of it being lost is not going to hit you. But if you're going to sell your house and borrow money, this and that to do it, I don't recommend doing it. Not a beneficial program. That's that. But the big ones you're going to deal with are EB1 through 3. There's 2 of these. Almost all of these require the employer to file for your green card. And this is one of the reasons it's troublesome with the immigration system. We're looking at the H-1B, for example, or these employment-based categories is the employer holds all the cards. and they control you. We see this with a lot with people in India who came here on H-1Bs and want to apply for a green card, because so many people from India have applied for green cards based on work and stuff. They have a backlog that's years and years, decades long sometimes. And so what happens is these people have to keep working here on their H-1B, and they're under the control of the employer. And so it creates a really difficult situation for them because they're not in control of their destiny. But there's two options for those who want to be. There's the EB-1A, Employment-Based First Preference A, called Extraordinary Ability Visas, similar to the O-1, but a little bit tougher. You have to show your higher level. And another one called the EB-2C, Employment-Based Second Preference, Category C, for National Interest Waivers. And if you're a scientist and tech person, this is a big one that they use. Essentially, you're saying, I have experience in an area that's really important, that's going to affect all of America. Let's say you're dealing with climate change, you're dealing with technology, you're dealing with sciences like cancer research, whatever it is, that's really important. And I'm set up to continue this important stuff and make a big deal, make a big difference if I'm able to get a green card. So waive the requirement for me to have to jump through all the extra hoops I have to jump through for a green card. Waive the requirement that I need an employer, although it's good to have an employer to show you have work and business lined up, and just give me the green card. And the requirements are not, they're open-ended. The statute's kind of up to the officer kind of thing, the way they've written it. And so then it becomes a PR letter, public relations, to say, listen, I'm the greatest there is. And one thing I've noticed in doing these kind of cases, both extraordinary ability and national interest waivers, is a lot of you guys are humble. You're studying, you're focused on your work, and we have to brag about how great you are. And sometimes it's really hard for a lot of people to do this because it's so weird for them. But we have to let them know you're the greatest thing out there, and you have to be in America because it's going to make our country greater. And so these options allow you to file for yourself, but you need a lot of documentation and sell it and go. Now, that's the EB-2C. It's broader, it's more evidence, but it's a little more, it's supposed to be a higher standard. It doesn't have, it's not a higher standard, but it doesn't have fixed things they have to show to make it like, very specific on what we need to do. The EB-1A extraordinary ability is something I do more of. And in that category, there's criteria that says if you have 3 of these 10, and in the totality of the circumstances you look good, we'll give you a green card. So for example, one of the 10 is, have you won awards of national and international acclaim? Another one is, are you a member of important committees and organizations that are hard to get into? Or have you had articles published about you? So for scientists, a lot of times for both the EB-1C and national interest waiver, we have articles that are published. So we preferably go to Google Scholar and you have a high citation rating, which is problematic because some fields don't have too many citations because there's not a field that gets written about a lot to get citations. But we can always explain that. But that's one way to get a criteria, show your skill. There's awards. You might have won an award for a bunch of money for research. There's all these different ways we could show, especially EB-1A with specific criteria, to kind of knock them out to show you're great. So that was the EB-1A, which is similar to O-1, and the national interest waiver, EB-2C. Let me go through the rest of EB-1. So there's EB-1A, extraordinary ability. There's EB-1B, which is if you're, professors a lot of time get this, or if you're working at a research institution, it's a great way to get it. It has criteria, much more simple, but you need the participation of the university or the research institution to help with that. And then there's EB-1C, multinational manager, similar to the L1, which is if you work for a company abroad, transferring over here, you're an executive or manager, then you're requesting that, requires an employer to do that for you. But then the next thing, EB-2 and C, the basic EB-2 and C, is you have an employer who wants to file for you because they can't find anyone else in the United States that does this work, and so we need to hire this person. So it's a 3-step process. First, you find out how much this person is supposed to get paid to show you pay it, do advertising in newspapers and the like to see no one else is there to do the job. And then you file a request with USCIS for that. And if it's approved, or sometimes at the same time, depending on what country you are, and I don't want to go too much into the complexity of it, you apply for a green card or adjustment of status if you're in the United States, or wait for your place in line to come to do consular processing at the embassy. So this is what a lot of people do. Which is just through an employer showing that there's no one else that could do the job where you're located, so they have to hire you, and the employer is going to pay you what the government, U.S. government, thinks is the appropriate amount to be paid, and you get it in. It works a lot. It's a lot of people historically have done these categories, but your employer controls it, and they have to be willing to pay for it. A lot of times, you'll find jobs and say, okay, you pay for it. Oh, listen, you give me cash to the employer, and the employer will act like they paid for it. Because the regulations say for at least the first 1 or 2 steps, the employer has to pay for it. They don't want people, foreign people paying an employer to say, hey, give me this job and I'll get it. I'll pay for everything. I'll give you $20,000, $30,000. That's fraud. They don't want you to do that. Even the lawyer has to be paid for the first 2 steps from the company, not from the foreign person. So what happens is the lawyer then kind of has their loyalty to the employer, even though it's supposed to be split between both of you. And that's one of those things. So if you are going through the process of an employment-based case, I highly recommend having your own lawyer go through things, especially for adjustment of status, to make sure you're not being taken advantage of. A lot of times the lawyers from the employer either, there's ways for the employer to keep you working at a lower wage while the case is pending and keep kicking things down the line for you to, to control you. It just happens, So you're hoping that the case gets done and you follow up your employer and say, or the lawyer say, what's going on? They say, oh no, we're dealing with it. And they're not. They're kicking their heels and whatever's the saying for that. They're just being slow so they can keep you here in some way and pay you less. And that kind of stuff happens. So you want your own lawyer to kind of watch out for things to make sure there's no mistake, because sometimes, and I see this, where the employer's lawyer doesn't know certain areas of law and they make a mistake. For example, you might be here working on an H-1B and they apply for your employment base. Your wife and children are overseas. They're supposed to be going through the process as well. Eventually, a certain paperwork you have to submit for them. And I've had lawyers not know which paperwork is supposed to submit for the family, which caused unnecessary delays and created havoc for their personal lives. So it's good to have your own lawyer. Talk to 5 lawyers, and as a saying I always say is, you talk to 5 immigration lawyers, you're going to get 6 different answers. Half of them are going to be right, half are wrong. Sometimes you'll get answers that are completely opposite, but they're both right. So it doesn't make sense, especially if you're coming from a STEP major, expecting the world to make sense. Immigration is all political. It's all politicians making decisions over time. So the rules don't necessarily make sense. It's an emotional kind of rule-making system. So it's inconsistencies everywhere. That's why talking to a lot of different lawyers, get different opinions is a good idea. We have a question right here. I'm a postdoctoral. I've been told I can start an application for O1 merits visa. Yeah, you can do that. Which milestone should I achieve before hiring someone like you to make my case? For instance, minimum 100 references and papers. There's no milestone. It depends on what your background is, what you've done, and how it looks. Now, I myself don't do O1 visas, but I could always connect you with the person, or check out the magazine. See if someone kind of talks the talk of what kind of work you're doing. Let them know you learn about them from the magazine. But I'm not an O1 specialist, to be honest. I've worked more on EB1As, extraordinary, but the green card version of it. There's no milestone. It really depends on what you do and how we can show that you are great in what you do. And that's the main thing when you're looking at O1. And if you're looking at O1, you might as well potentially look at a national interest waiver green card. If you have a doctorate, postdoctoral, why not go for the gold and just get the green card? So that's the best answer to that one. Can you give us your contact information for J1 visa waiver options? Email me and let me know how you're subject to the J1 visa waiver. I don't do the Fulbright waiver, but maybe you can do the other ones. My email is info@jqqlaw.com. I'll type it in the notes. Info@J as in Jack, Q as in Queen, K as in King, law.com. Email me. I usually have a consultation fee, but email me, let me know from here, and we'll figure out something. At least do a basic review and take it from there to help you guys out. All right, so those are the basic categories for employment. There are some side stuff we always ask people, like humanitarian style. Now, I don't do any of the humanitarian cases, but let's say you're here, you're from Iran, and you can't go back home because you became a Christian. You go back home, they're going to chop your head off. You say, okay, asylum, I don't want to go back. Asylum's an option. TPS, temporary protected status, is something that says, you're from what country? It's like, I think El Salvador had an earthquake like 20 years ago, and they said it's too dangerous to go back. You can stay here while things get better. We had that Ebola outbreak in West Africa. They said you can stay here, TPS, till things get better. Haiti has the earthquakes. They can stay. So there's different things that pop up. Venezuela has this right now because of how bad it's gone in Venezuela, where you can do TPS and stay here. There's more nuances to that, but that's there. There's a T visa for people that are victims of sex trafficking. There's a U visa if you're a victim of a severe crime. There's a list of crimes. There's an option to get a work visa and eventually get a green card potentially. So these side things are there. We mention it because someone may come to the office, they could do all this kind of other stuff, but then someone try to kill him for some reason. A jealous coworker try to attack him and kill him, attempted murder. Well, you can say, hey, let's do the U visa route, have that as a backup. Why not have additional backups? Hopefully you didn't go through that. A lot of these humanitarian cases, hopefully you don't have to do it, but hey, if your life changed in a way that makes it able to get these, why not use it? And the last note here is about inadmissibility. It kind of goes back to the first stuff I talked about. Inadmissibility says who cannot enter the United States, or who will get kicked out too if they're here. A couple of them that people don't expect is, if you are not a U.S. citizen and you claim to be a U.S. citizen anyway, you vote, you've been registered to vote sometimes, you get a job, you fill out a form that says you're a U.S. citizen, put yourself out there like that. That's like committing murder in immigration. They're going to kick you out. So false claim to citizenship, very, very serious immigration crime, if you will. Overstaying visas could be problematic. There's mental health issues. Some people may have attempted suicide in the past. 15 years ago, they may hold it against them. Some people have drug abuse issues. Obviously, criminal history could be a problem. So there's different things you got to be careful for inadmissibility. Most of the time, you don't have them. But that's goes back to the basics I go through every case, because I got to spot these issues first. I got to make sure you're healthy before you can figure out what kind of positive things we could add to your situation. Now, we're about the end of my talk right now. I think I went through everything pretty fast, but trying to fit it within the hour. We have a question that says, is it possible to update the DS-160 we filed to get the visa? I got married after getting my visa. There's no way to update the DS-160. You could file for a new visa, but we have to see what happened. So if you were not married and you got the DS-160, then it's okay. Now, I think on the DS-160, the application, it asks if you have a fiance. I think it's more if fiance is in the United States or not. I can't remember exactly. You may have need to fill that out. But let's say, you got the visa and then a year later you fall in love and get married, then that's a separate thing. That's that. Now, if you want your spouse to get the visa as well, they could apply for their own visa, J2, for example, or L2 or 03, 04, or something like that. All that's possible. I'll need to see what's exactly going on, the timelines of your case, Clara, to be able to put that out there. But you can't update the DS-160. You might need to file a new one and go through a new visa. If that's needed, may not be needed. Let's see. Echo says, everyone help us create specific events around immigration focused on your needs. If you have any requests, email us at boston@ecusa.es and we'll help you for sure. Definitely do that, ECUSA or ECUSA. Thank you so much for having me here. It's been a pleasure. If you all have some follow-up questions, let me know. We have one right here. How much is the average cost for my company to pay if I apply for an EB2C green card? So EB2C is, employer doesn't have to pay for it. That's for you to pay for if you want to, so because it's self-filing. How much, some lawyers charge $2,000, $3,000, some charge $15,000, some charge $30,000. It really depends when pricing is, how complicated your case is. So let's say you won the Nobel Peace Prize or Nobel Prize for Science. There's not going to be that much work related to your case. It's going to be cheaper. But if you have to do a lot more work, it could get more expensive. So that's the short answer on that. My husband is asking now for a J2 visa, so I wanted to be sure he can do it without a problem. Since I was not married when I got my J1, thank you for your response. I can't give case-specific advice here, so I'd have to really get down and talk with you about it. But it's possible for them to get the J2. It will be up to the embassy whether they approve it or not. It just shouldn't look like you're lying when you got it, but I don't see how being married and stuff would be that big a deal in this case. So it's probably okay, but I'd have to review the whole thing. But always remember, at the end of the day, it's up to the discretion of an immigration officer. So you have sometimes perfect cases and they'll just deny it. So that issue does exist. Dr. Maxim says, any advice on how to accelerate a J1 visa renewal administrative processing for postdoc? Oh, I put notes. I remember the one of the first questions asked too. Sorry, I missed it. But we have a big problem with things being delayed. What do you do about that? So one thing is you contact USCIS. You could contact the congressperson of the jurisdiction you're going to be working at, for example, or maybe the institution you're working with, and contact the senator that says, listen, you're doing important work. This is stuck. Why is it not moving forward? They could try to contact the embassy and push it forward. May or may not work. But the solution we're seeing more nowadays are lawsuits. People suing the government saying there's unreasonable delay in this administrative processing. So for those who don't know, some people go to visa interviews. Everything looks good. The officer says, let me think about it. We'll follow up with you. All of a sudden, 3 months, 6 months, 9 months, a year, 2 years go by and no decision. You're stuck in this limbo and nothing's moving forward. So you try contacting a congressperson, a senator, say, help us out. If that doesn't work, you contact the embassy, say, hey, push it. That doesn't work, which is usually the first two don't work. You file a lawsuit, and again, I can't tell you to file a lawsuit. It's up to the, talking with a lawyer about that. And see, they contacted a congressperson. They're still waiting. A congressperson probably not gonna do anything, but you want to just go through the steps. Eventually, if it's really important, you file a lawsuit. It may or may not work, but at least you'll get some finality on the situation. But that may be the way to go. We have a question. Would you mind to repeat which are the specific client profiles that you're currently taking, like which kind of visas you work with? So a big part of my work is with marriage cases. So we have so many universities here in Los Angeles. People fall in love with their classmates. So I primarily do marriage green cards. And then secondarily, L1 intercompany transfers and the green cards and visas for people transferring, as well as the E2 visa. So those are there. And then, TNs and Canadians, for example, we do those depending on how good the case is. And so those are the basic ones. So also EB1A, extraordinary ability, more so than the national interest waiver. So, family, marriage kind of cases, people doing intracompany transfers, transferring here, investor cases for E-visas, not the EB5. And the other one I talk about, EB1A, extraordinary ability. But I'll be honest, I pick and choose my cases. So I like to see a resume. If it's good, we have a consultation. It's a paid consultation because we got to really check out the situation, what's going on. And it takes time to think about it and to analyze it and do research and see if I think USCIS will accept this. But those are the big ones. Thank you for the question. It's an important one. I don't do O's, but do the green card version of it. If you're interested in those, you always contact me. I try to connect with a colleague. I'm not currently doing H's, for example, but I have a friend here in Orange County in Southern California who does those. So there's options. It's just, thinking what makes sense for you. Go on YouTube, research it, watch videos and stuff. You're going to have people saying different things, but it's always good to do your own research and try to figure things out too. So when you go to a lawyer and you ask questions, you get a better sense of if they know what they're talking about or not. So that's really important. We have a question for J-1 visa. Can you lose it if you already started the process to renew it, but you reach the expiration date? So I got to see where you are in the process, but typically if you're extending your case and you've timely filed for an extension, you can stay in the United States while the case is pending. Whether you can work or not always. Depends on what kind of work, what kind of visa you have and all that stuff. Typically, you probably can't work, but it depends on what kind of J it is. So I need to know more information. And one thing that's important to know that is when you get a visa from the embassy to come in the US, there's an expiration date on that. That is not your expiration date in the United States. So I see people who come on tourist visas and they're given a 10-year tourist visa and they think that they can stay in the United States for 10 years. That's not correct. The time you can stay is based on your Form I-94. They used to have a piece of paper they would staple on your passport. They don't do that anymore. They have a stamp in there. The stamp is not reliable though because the officers don't pay attention and put the wrong date sometimes. You type in I like Ida, or is I will like info, I like info, dash or hyphen 94, and you go to the CBP website, you put your passport info in, and that tells you how much time you have in the United States and if you're expiring. And one note is if you're on an F-1 or a J-1, the time will be a thing called DS, duration of status, because they know there's, sometimes school goes longer instead of 4 years, like 6 years or whatever. They don't have a fixed end date for these kind of visas. So you don't know when the expiration date is exactly. But if you're going to renew it, that's what I have to see when you're saying out a J-1 renewal. I have to see exactly what kind of case you have that you're renewing. Many times you go update your DS 2019 and the school could update it. So I'd have to see what's going on exactly with your case to be able to give advice on that. All right, seems like I think we're out of questions. Hopefully I was able to help. My email is info@jqklaw.com. Thanks again to ECUSA for giving me this opportunity to talk with you all. Farhan, if you want to come on and mention anything, let me know. If not, thank you everyone. God bless. Hope you're able to get your immigration stuff in order and you're healthy and you're staying away from this COVID situation, which is killing us, literally and metaphorically. So on that high note, God bless you all. Thank you so much. And hopefully I'll get a chance to talk with you in the future.